Put him on a hearing for tomorrow. Okay.
You want to bring it back tomorrow?
Yeah, we'll bring him back tomorrow.
All right, be back tomorrow at 9 o'clock.
I want the state to sound in on that and the probation office. Gary Boudreaux. What are we, on this one?
Your Honor, I've been waiting here. It's more than have this, but I'm waiting for some videos still. I need to complete that. I was gonna get in touch with Karen.
Well, it's been 2 years since this guy's been indicted. When are we gonna go to trial on a murder case? When is it set for trial? How long have we been in on it?
I think since July.
Who was before you?
We had to bench warrant him back from prison. He's doing another sentence somewhere. And we tried this case and an individual right in the middle of trial decided to plead guilty. So this is another one came out as plea. Another.
I don't understand that. I don't remember that.
We got some more information. And so this, we had to have him bench warranted back from prison. He was in prison, so it took a little while to get him back.
Yes, sir. He didn't get here until July.
What are we doing today? What do we need to do today?
Your Honor, I'm just
Mason,
asking
this-
for another announcement.
For how long?
30 days.
All right. Brent,
Make sure you get the phone.
what else? And who else is still left?
Jessica.
Okay. Who does this?
It's this. Here, Judge.
These motions to revoke probation on Jessica Robinson.
Yes, Your Honor. These are ones
We having a hearing on that?
I think we're going to plead true and let the court decide what to do.
Right
They're
now?
all administrative. That's you'd like to, right? Yes. Because they're just not reporting and money.
It's technical.
It's all technical violations.
What state, what's probation say about this?
Well, she failed to report for the months of June, July, August, and
How
September.
much time does she have acquired, please? I guess that's an important thing. These are all state jail felonies.
Yes.
I think she's been incarcerated 46 days.
It's been since October 17th.
46 days. You Honor, the probation department was going to ask the court to allow this case to expire this month on the 20th due to her inability to pay, because she's been on probation for 10 years now.
I understand that. That's,
She quit reporting, so we could
Okay.
not address the situation.
that's more of a problem. Is if you don't report, you're not on probation. You're on your own probation, which is not the way it works.
28 days.
Huh?
Total 120 days.
All right. Does the defendant waive formal readings of these motions to revoke probation in each of these cases? Can we proceed and so?
Yes.
And you were Jessica Robinson? Raise your right hand. You have to speak up so she can hear it. You solemnly swear or affirm every statement you make will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand. In 13-17068 and 16-24775 and 16-24776, you are on probation as of June 21st, 2016. In each of these cases, as you were placed on 2 years state jail. No, 2 years. No, it can't be easy. It can't be. It's not going to be. You were sentenced to 2 years in the state jail, and that was probated for 5 years in 17068 for the state jail felony of abandoning or endangering a child. Then
I know. I can do it on that.
in 24775, this states that you were sentenced to 2 years in prison, suspended for 5 years for the state jail felony of abandoning or endangering a child. That can't be right. Right? You can't send somebody to prison for a state jail felony, right? And then 24776 states you were sentenced to 2 years in prison, probated for 5 years for a state jail felony of abandoning or endangering a child.
I think you're.
Isn't that wrong?
Yeah, I think it should be a 2-year state jail probated over 5 years. I think the motion maybe.
Is that Does that agree with?
Which motion?
The motion will say TDC versus state jail.
775 and
2 years in
776.
the state jail division of the Texas Department of Criminal Justice, which is right.
It says she was sentenced to 2 years in the institutional division.
Oh, the other one
In
I
those
have.
two. In these two,
Okay.
and then state jail in this one.
It should follow
We,
that.
we moved to amend and add state jail before the institutional.
No objection.
Isn't that right? You were in the state jail, correct?
She hasn't gone at all. If she violates that, what her punishment could be.
Was she originally placed on deferred?
That was speculation, right?
Because I saw the judgment said that she pled true on one, that she.
It's two cases. Yes, she originally used it together. So, yeah,
Yeah, they all.
That was back in 2013, 16, 2013, maybe that one. Yeah,
The original.
the original one, I think she was deferred on,
I think you're referring on that one and it got these two.
because I see a judgment sentence.
I think
she
she
pled
did
true.
straight probation, three of them, that one was converted from deferred to straight.
That's why I started so much.
Yeah. Yeah.
On each of these, they similarly allege
It's okay.
that on June 21st, 2016, in this court, you were sentenced to 2 years in the state jail and that was suspended. You were placed on regular probation for 5 years for each of the state jail felonies of abandoning or endangering a child. Is that all of that true? One states you failed to report to the Jefferson County Probation Office. In each of these motions states you failed to report to the Jefferson County Probation Office for June, July, and August of 2025 in violation of Condition 4 of your probation office probation order. And that was the last time you reported. Is all of that true?
Yes.
Are you pleading true to allegation 1 in each case voluntarily and because it is true as it is alleged that you failed to report to the probation office as ordered?
Yes, sir.
Do you understand that one or more violations of probation is all is needed to prove by preponderance of the evidence or greater if proven to revoke your probation?
Yes, sir.
And you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, you insist on pleading true in each of these cases.
No.
Is that correct?
Yes, sir.
I find you were pleading true voluntarily in each case. And you understand and appreciate the consequences of pleading true to allegation 1 in each case, which is failing to report to the probation office. All right. There is no agreement here.
No.
Go ahead.
Your Honor, we would ask to continue on probation. She is due to expire on, I believe, later this month. I'm not sure the exact date. 20th. The 20th.
28
She's behind significantly on fees. She did miss a few dates there, but she has been on probation for a while now and has been doing okay. So I'd ask the court to give her a little more time. I know we can't dismiss this motion to revoke probation because it's about to expire, but hold it in abeyance and let's come back in several months, see if she's making some payments and making some effort towards getting on the right track. I think she knows she needs to, and see if we can get this caught up. She owes, I believe, 4,000, 5,000, something like that.
She owes $4,902.
I was right about $5,000.
How much is she paid is the question.
Your Honor, she's paid $4,564 thus far, with all 3 cases combined.
Yeah, she's paid about half of what she owes, and she still owes more money. She needs to focus on getting this paid as fast as possible. But I would ask.
Showing up and reporting is kind of important.
Absolutely, but she has been reporting in the past, right? These allegations are for those months there you allege, but
No, she walked off the child though.
she didn't finish. She didn't finish. I know. She at the end she stopped reporting. But I think now if we now that she's gone to jail and sees what it's like, I think she knows she better not do that. So I would ask the court, let's let her out and leave these open because obviously we need to leave them open, and then come back in 3 months or whatever the court determines a good time to go back and see if she's doing anything at that point. She might not be. I mean, we'll know.
What state saying?
Judge, on the original case, looks like she was given deferred and she got those 2 new cases and was given another chance on probation. And we know that reporting is important, that it's one of the most important things that we have to do because we can't supervise them if they don't report. If she gets back out, she's just going to be supervised by same probation office and have to pay money and do the things that she was supposed to be doing beforehand. So I think a good solution would be, since she's got some jail time, but not the full, that she get 180 days state jail. That way she'll have to do some more time in state jail, and probation won't have to supervise her anymore. She'll have her convictions, her time, and going about her business.
It's a long history here.
Yes, sir.
She was on deferred or unadjudicated probation in 13.
Yes, sir.
Then that was changed to regular probation. She gone past the 5 years?
She was extended several times, Your Honor. She had 6 different probation officers before I received the case. So I tried to address it immediately.
The total amount of time credited in her service is 138, did you say?
128.
128, Your Honor.
I don't see how keeping her on probation any longer is we've exhausted all the options and we're still coming up with problems. All right, I understand. Anything else to add? Would you like to add anything there? No. Then I'm going to find that there is sufficient evidence supporting these motions to revoke probation to grant them by a preponderance of the evidence or greater. As allegation 1 has been proven true in each of these cases by a preponderance of the evidence or greater, since the defendant has admitted failure to comply with the reporting to the probation office as required, and allegation 1 in each case is proven true. Thus, the motion is granted. Your probation is revoked, and you are hereby sentenced to confinement in the state jail for 180 days, which is the minimum. You will be given credit for all time you have served, and these will all run concurrently, as you know. And hopefully you can move on with your lives with this. I think that is in the best interest of justice under these circumstances. That is all. All right, what else?
I don't have a file. Oh, that's just really cool.
I have 2 cases. What are we doing?
MTRP is, MTRP is 127, big true, county time. Dismiss on these stages.
That's right. I forget that.
We're actually resolving 3 cases today.
I get it.
There's most of the above probation here, 25 CR 2092. Raise your right hand and solemnly swear or affirm any statement you make during this hearing of the truth, the whole truth, and nothing but the truth. So help you. Can we proceed, son?
Yes, Judge.
In summary, this motion states that on June 16th, 2025, in this court, you were sentenced to 1 year in the county jail, probated for 2 years for a Class A misdemeanor of theft. Is that true?
Still need to approve on count 1, Judge.
1 states you committed the offense of theft of property, which I guess. No, well, it's not this one. The offense of theft of property on or about September 23rd, 2025. You see, that's not going to help us because we're going to have to go through all the elements of it to prove them up. And just, it's going to have to, the police going to have to support all the elements. I've got this new indictment of illegal possession of controlled substance. She pleaded guilty to that. Okay, is that?
I'm sure it's not right. Because that offense predates her probation.
Just pleading guilty, that's all I'm saying.
If the court is all right with something other.
Yeah.
Or she's got, she's got
Finding a urine
positive-
sample on or about September 16th, 2025, that showed the presence of marijuana and methamphetamine in violation of condition 10 of your probation order. Is that true or untrue? Are you pleading true voluntarily and because it is true as it is alleged? You understand that voluntary and knowingly made plea approved of one or more violations of probation is all it takes to grant this probation? To grant this motion to revoke probation, your probation can be revoked. You can be sentenced to 1 year in county jail, knowing that you insist on pleading to today. Yes,
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading.
Yes, sir.
Number three. Three.
The agreement's been reached, you would be sentenced to 1 year in the county jail. Is that your understanding of the agreement? If I follow that, you have no right of appeal. Do you understand? Anything else? I'm going to follow this agreement and find that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greatness. The defendant has knowingly and voluntarily pleaded true to allegation number 3, which is a violation of condition 10 of the probation order by providing a urine sample showing the presence or possession of marijuana and methamphetamine. That supports this motion by a preponderance of the evidence or greater. Thus, your probation is revoked and you are hereby sentenced to confinement in the county jail for 1 year. You'll be given credit for all time you have served in accordance with that case. Do you understand what's happened there?
Yes, sir.
Then what's she pleading to 1293?
Yes, sir.
That's what we use.
Does the defendant, who's here with Mr. Turk, our attorney, waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, we may, Judge.
In summary, this indictment alleges that on or about September 4th, 2024 in Jefferson County, Texas, you committed the second-degree felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with here?
Sir.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. We're putting on a regular probation.
Straight probation.
10 years in prison, that would be suspended. You're placed on regular probation for 10 years. There would be terms and conditions of probation, which you have had trouble following. That would be necessary, or else your probation could be revoked and you could be sentenced up to 10 years in prison. Do you understand what the plan is?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes, sir.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
Show you what's here. Most States Exhibit 1, did you sign that? Understand it? Discuss it with your attorney? Is everything true and correct?
Yes, sir.
States Exhibit 1 tendered. Without objection. This states you are mentally competent at the end of your guilty plea. It's freely and voluntarily made. We know what you've been charged with. The indictments because you wrote it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to verify and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
Pre-sentence reports waived.
Yes, sir.
Nothing further. I'm going to find You are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from state's exhibit one admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of illegal possession of a controlled substance named methamphetamine. I'm following the agreement, hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation of 10 years. There will be terms and conditions of probation, which will be reviewed with you by the probation office. Please make sure you follow them. They are important. If you fail, again, you know, your probation could be revoked and you could be sentenced up to 10 years in prison. Thank you. Anything else?
The state's going to dismiss
I'm gonna dismissal over for you.
All right.
As a misdemeanor.
Thank you. That's all.
Prosecutor will give her time, sir.
He's about to.
So that.
Let's get ready.
She needs to get that done or else it was slow.
Okay.
Second.
You said today for us? Yeah. You said.
Yeah.
See. All right. We're in recess.
How are you? I'm fine.
That was Thanksgiving.
No, it was great. Well needed.
Did you keep your eye on your dad on the desserts?
I did.
Okay.
Gotta keep him honest.
How's that working?
It's harder than I said.
Good days, bad days.
Yes, sir.
Okay. On Mr. Birdsong and all jocularity aside, this is serious. You're charged with the first degree felony of murder. And what are we doing today?
Dad asked me to fill in for him.
Yeah.
He's been important to Jasper.
Yes.
And he just wanted to see if we could get a reset since he was tied up there.
Is there the state wants to be heard on this? Anybody from the state at all on this murder case? There we
There's a
go.
murder case up there, Jeff?
Yeah,
It's
it's,
on the fire.
We have serious things.
It's on discovery.
I understand. In fact, I'm not showing. I don't know who the prosecutor is on.
That's because I'm flying under the radar on this one, Judge.
I'm looking every resetting. There is no name for a prosecutor. But anyway, you're here.
I'm it.
They're asking for additional time. This is a case
Okay.
that we're going on 2 years, right?
Yes, sir.
So
I think we're getting close to if the next setting, if we don't work this out, we need to set it for trial. We need to do it, get it done.
okay, resetting 5 weeks. Is that good? That puts you, it was in the first full week in January.
Yes, sir.
And that build, kind of a fish or cut bait time.
Yes, sir.
Because, we're coming up on 2 years and that's time for a decision one way or the other on what direction they're heading. And
I know we're waiting for a while for Mr. Walker to get a expert to look at things, and I think that's been accomplished. We just hadn't had a chance to go over and discuss what's been found, what we want to do. And that's partly because of schedule difficulties for both of us.
how old was the deceased at the time of the
He was 70.
Okay. 5 weeks good?
Yes, sir.
Oh. Let me talk to the lawyer. Mr. Gavin. And on this one, what are we doing? It's keep coming with y'all on these. This is 2 serious cases today. What are we doing on this one today?
We're going to be asking the same thing, Judge. He's going to ask for a reset since he's out of the county.
Okay. This one getting old. This one going, it's over 2 years on this.
Invested.
So what's they say? They're asking for 5 weeks. The previous case.
I don't have any objections to that, Judge.
Yeah, I think but it's probably run out of, yeah, the announcement times. Thanks. And John Panita Brown, I think.
Yes. Weeks.
Let's go.
I'm sorry, but I'm first. I'm right there.
This is an announcement. She is in the process of repaying the victim. And the case is going to be dismissed after payment of all restitution. So we're just asking the court to reset while she's working on things.
When is that going to happen? It's already been 2 years
They have,
since it was.
yeah, the problem with this is U-Haul, and they've actually entered into a settlement agreement with her on a civil basis. Mr. Boyd's aware of it. He's agreed to let them continue to do that rather than pay the restitution through the DA's office, because they file these things and then they still try to collect it through their collection agents.
I've got
They've
email confirming how much is
yeah.
the
So
sale amount.
they're saying they're accepting it over 9 payments, 9 monthly payments.
Over 270 days.
Yeah, that's 9 months.
Yeah.
So that's the payment schedule that they've agreed on.
Judge, I'll talk to him. What we'll do is if they've got a civil worked out and there's payment plan worked out and they've signed everything, we may just get rid of it anyway, let them just deal with it civilly. But
Okay,
I hate letting her just be able to just walk away from the civil agreement. That's something.
well, also we're talking about dollar for dollar without an interest. These people have been without.
Yeah, and this is a reduced amount. I think this is saving her.
It was September 29th of 23,
Yeah.
so it's been,
Did
you know what? Let me speak and then you can interrupt. That's what frustrates this court. It's one thing when you're charged with a theft and you pay it back over years, but when you pay it dollar for dollar, those people have lost the use of that money for years. Really, the right thing should be, you ought to be charged in interest, whatever the interest rate is at the time, added to the dollar for dollar. Because if you steal, let's say $10,000 from somebody and pay it over time, dollar for dollar, let's say over 2 or 3 years, they've lost 2 or 3 years use of that money and they're out. They still, if you paid them all back, the $10,000, they're out the use and interest that money would have served them. So just paying them back a little at a time over years, the flat amount that was misused or taken doesn't pay back the victim properly. They lost value of that money. And that's why when you go borrow money from a bank, you have to have interest. You have to pay interest. You may borrow 10,000, but it's going to cost you 10,000 plus the interest, because the bank is losing that value and that worth. And that would apply not only to a bank, to anybody who loses money and then gets reimbursement. There ought to be interest charged, whatever the appropriate rate is at the time. But that's why this court has always been anxious when people pay it back. When you pay it back over years, dollar for dollar, they still lost money, and that's your fault.
Yes,
Then how do you just apologizing to them? They want money back, but they just get dollar for dollar. That's why it's important that it gets paid back as soon as possible, because they're going to lose something. They're going to be a victim and they don't get repaid 100% of the loss of the use of the money. So when is this going to be completed?
They gave me 3 months to do it. I was gonna try and have it done in the next month. Maybe for income tax time, I don't know. But the thing is, they have me for theft of the vehicle. They said that I stole the whole U. And at the beginning, we said that I didn't steal the whole U. So after I pay it off, is that still gonna show up as a felony?
No, ma'am, the case is going to be dismissed. The criminal case will be dismissed once you pay all the restitution.
Okay, so if I bring the settlement and pay them all before my court date.
Yeah. When it's done, all things being
We
done
dismiss.
properly as agreed, then they submit me a motion to dismiss the case and then it's dismissed. And that's why you can see it's a win for you, even though these people were out the money. But I am always concerned about the victims being paid back. And when you have to pay over years and it's just dollar for dollar, they're still out the use of that money for the period of time. They didn't get interest on it and they're out. That's why
Yeah.
it's important that people pay the money back as soon as possible. Okay,
It's not for us, it's for them. That's what we do with it if we got it.
so when's the next event? What do we want to set for a review? I mean, if she pays it back, if she pays it back, she doesn't need to come up here. I can dismiss the case. The quicker, the better for everybody.
Review it in about 60 or
But I'm
90
gonna
days.
review
Make sure
it.
she's got time to do it.
60 to 90 days.
6 weeks to review it. Let's see where we are.
All right.
Get it reset. And Noah, what do you mind?
27. Yeah. 27. Mr. Niemeyer is in Harris County Jail. So we need to reset till,
What do we need to do about getting him back here? Anything?
he is, my understanding he's serving some time
What do you
there.
want me to do today?
Give me about a 5-6 week reset.
6, reset 6.
Yes, sir.
Cynthia Payton.
She is here. You know, here, Mr. President. This is a motion to revoke probation based on a new possession case in Jasper County. She's in the process of hiring H.A. Cove attorney to handle both of those matters and asking for
I'm pretty sure
we said on that.
we're going to move forward one way or the other. We're going to move forward. You can get whoever you need. When shall we be ready? I want a motion, begin hearing. This was filed on August. We're moving fast.
Your Honor, we'll need to check on the case out of Jasper County.
Okay.
It has not been filed yet. They're still waiting on
It doesn't matter.
analysis there. It's going to take a while.
It doesn't have to be filed,
No, but they're waiting on drug analysis. They can't prove the drug until the analysis is done.
It's at the labs. We don't know the status of it other than the lab has it. But we haven't gotten the lab results yet on that.
Well, why does the allegation say she committed an offense if we don't know if she did or not? I mean, somebody signed something.
As soon as an arrest is made.
I know I know, but if you're not sure, it's one thing about it. I mean, if we're all held up because we don't know if it's a drug or not, how can you, in good faith, allege a crime?
I 100% agree with you,
All
but
right.
that's always been the policy of the state.
When is this going to be known for sure?
Don't know.
I know, I'm asking.
I'm not sure, Your Honor. I can check on it. Yes.
Because I want to move this when motions, there's no reason for motions to languish. We're going to work late if we have to, but we're going to move motions and they're not going to languish. After we're ready to move. And this, and
Sorry. Problem.
Okay, I'm looking at the administrative hearing. And it doesn't even identify a drug. So the random urine screen was administered and was negative for illegal. She was advised any more violence. That was October 11th. That on the. We're talking about July 17th, 25. There's July 10th. Rated the offensive possession. Yeah. Then on inactive. It was arrested for new felony office. Offense. But yeah, that's odd. Generally, they identify a drug. There's something, some test that it would at least get some up, but it's an unknown thing. That's odd.
We will try and look into seeing on the status of those lab results, Your Honor.
Okay, I want to reset it for 6 weeks. That's just. Okay, Elijah Watson.
You can stick around if you sign. You can stick around if you sign 3 cents.
Elijah Watson.
This is a relatively new case. I've talked to Mr. Watson. He said the process of our attorney, so just asking for about 5 or 6 weeks set. So you can do that. It's a pretty new case.
Who are you hiring?
Miss Jennifer.
Miss Jennifer.
Jennifer Douglas, Port Arthur. Who's the person, that's the name he gave me, but he's also talked to other attorneys as well.
Okay, you're charged with a 3rd-degree felony of evading arrest,
Thank you.
as you know, which carries with it up to 10 years in prison. So it's a serious situation. The okay, on October 28th, we reset this to today because he's trying to hire an attorney. When are you going to not just talk about it, but do it?
Yes, sir. I was homeless for a little bit, and when I was trying to make the payment arrangement, she wanted it right then and there. And
Right now, you've got a lawyer. Then you can hire anybody you want, but we're not going to wait on you. We're going to move forward one way or the other. You've got a lawyer here, this man, and we're going to move forward. I'm going to reset this for an announcement, and in 6 weeks, and we're going to have an announcement one way or the other.
Question.
Okay.
You'll set a reset.
Yes, we're not going to wait on you. Christopher Clinton, Brian. This is so thick.
Well, we've been dealing with it for a while. This is the case that has the sex offender registration determination that is part of a civil case in Austin right now.
What do we do today?
There's not much we can do until that determination.
What do you want to do today?
I'd like to ask for 6 more weeks and we'll look him on those.
What's the forecast on it?
Judge, there's a new district court judge in that court, unfortunately. So
Travis?
In Travis County, yes, Judge. Any of the statute requires us to litigate this issue in Travis County.
I'm glad you're here in Jefferson, where we have some control.
So hey, on the good side, Judge, this is the only one of these that you have, so.
What, tell me a little, just in a sentence or two, what's the deal on this as far as what are the options that can be headed toward?
The court could say, the district court over there in Travis County could say that he's not required to register as a sex offender because the statute under which he was convicted in Arkansas when he was 18 years old is not equivalent to the statute in Texas.
We don't accept.
In other words, he was convicted of a misdemeanor in Arkansas when he was 18 or 19. And what the DPS did was they are treating that like it's in 2nd degree indecency with the child. And the two things are not the same thing. At least that's our argument. The district court may disagree with me about that, but the elements are different. The offense is different. The level is different.
Is the requirement that it be a felony or be defined as a sex offense?
Judge, it's the answer to the question is there is no requirement that it be a felony, but there are no felonies under or misdemeanors under Chapter 62. So do with that information what you want. But the real answer is, Judge, the offense for which
there a related crime?
I would say no.
The elements?
I would say no, because, and I'll tell you why. Because the offense for which he was accused was having consensual sex with someone within 3 years of his age, when she was 17 and he was 19 or 18 or whatever it was. And the gist of it is that in Arkansas was a misdemeanor sex offense, but in Texas that wouldn't be an offense here.
Well, it would have a defense.
But if it meets all of the elements, it'd always be a summary judgment defense. I mean, it would not be an offense, but certainly not what he was convicted of in Arkansas as a misdemeanor, certainly not the equivalent of indecency with a child or acts or sexual assault of a child in Texas. It's just the elements are not the same. And what DPS has to do these charts for each state and say these crimes in this state equal these crimes in Texas. And our argument is when they did that chart, they did this one wrong as it relates to that offense in Arkansas. And then for whatever it's worth, to make things even more complicated, the legislature about 2 years after his conviction in Arkansas completely changed their whole penal code. And so now it's totally different. And that rule doesn't even exist anymore. But that is not even a crime in Arkansas anymore, what he was convicted of.
Right.
So
what do we want to reset?
I mean, 6 or 8 weeks, Judge.
All right.
Yeah.
All right. 7.
Thank you, Judge.
Good resetting.
Thank you.
Then that goes to Langston's case. Did anybody see Mr. Pollard at all? At all? Is he? He's blending in. He's blending in with the scenery. Is he here around?
He's here live and in color. It's live. That's just our first.
Hey, it's going on 1 year as an indictment. I mean, where's he been? What took so long?
I think I got the case in October when they assigned me to it.
Yeah, this isn't good though. He's got all those priors, huh? So is this habitual felon on 138? Looks like, I'm afraid.
I know
Yes, yes,
Yeah.
Right.
And then the state jail felony in 139 is going to be punished as though it were second degree. Is that right? What's that? You got sequential. You got 4 sequential priors. So this is serious. What do we do?
I think they're gonna give me some time. They gotta convert the files where I can print them on the discovery portal. I think the DA's office is gonna convert them for me. But this is my first appearance with him over there. I know you said the case is a year old. Like I said, I didn't get this until I believe October.
Oh.
Yeah.
All right, this is 6th resetting already. This is a 6th resetting already. Langston. I didn't matter. I mean, he can change lawyers every time, and then that would be his excuse. I got a new lawyer.
No, I think it's a technical issue.
We need to. Technical issue is just he's changing lawyers, but it's, the court's gonna move forward. I mean, you don't have at least a year rule. There isn't anything. It's moving forward and you want to keep changing lawyers, that's okay, but you're gonna work on my speed, not on yours. We're not gonna do that on yours. Mr. Pollard. I went he's got 4 weeks.
That's what I thought.
For.
We'll just do like.
5 weeks. 5 weeks for a decision, what direction we're gonna head in.
No, that's no
Then,
problem.
then it will go that direction, okay?
No problem.
And of course, we try it, it'll be, I guess, the unlawful possession of the firearm case. That's the one that's looking at life in prison. You're looking at a minimum of 25 years, minimum of 25 years to life in prison on that one. And then the other cases, no less than 2, no more than 20 years confinement in prison on that. It's all because of prior convictions, which is what is the factor in the penalization is the circumstances of the crime and criminal history. Your criminal history is terrible. That's why it's always, my advice to you is don't commit any more crimes. I should have given you that advice before you. Anything else? That is all.
Thank you.
Okay, let's get ready